This video is sponsored by Aura. Spam calls got so bad for me, I just decided to give up. And spam texts, they're endless. What I decided to do is only allow family and close friends to ring through. Everyone else, straight to voicemail. But then I have to manually delete all of the spam texts. But here's the thing, my setup is far from perfect. I can't tell you how many spam texts I delete every day and how many calls I miss from important people. It's frustrating and frankly, it's exhausting to deal with. And it turns out there's a reason we're all bombarded with spam calls and texts, and a lot of it comes down to data brokers. These companies collect your personal information, like your phone number, and they'll sell it to anyone willing to pay, including scammers. It's a huge problem. That's where today's sponsor, Aura, comes in. Aura helps to remove your information from data broker sites, making it so much harder for scammers to find you. And finally, I can let all of my calls ring through and still have some peace of mind. But Aura doesn't stop there. They offer a full suite of tools to protect your identity and finances. They monitor for signs of identity theft, alert you if someone tries to open a credit card in your name, and they even include a VPN to keep your online activity secure. It's everything you need all in one app. And here's the best part. You can try Aura for free for 14 days at aura.com/gavinfish. Don't wait until you've been scammed or had your personal information used against you. Go to aura.com/gavinfish and take the first step toward protecting yourself and your family. Stop leaving yourself vulnerable to spam calls, to data breaches, and worse. Let Aura do the hard work of protecting your personal information. Again, head to aura.com/gavinfish and start your free trial today. Hello and welcome. Going to do a little mic check here. Sound check, check one, sibilance. Yeah, we're here. Guys, thank you for joining me tonight. I understand it's a little bit later than usual for everybody on the live stream. For the rewatch crew, you're just like, whatever, Gavin, get into it. And get into it we shall. Tonight we are talking about the case of the murder of Kouri Richins. Eric was 39 years old. He was a stonemason from Francis, Utah, owner of his company, is an entrepreneur. And on March 4th of 2022, he overdosed on fentanyl. Now, I shouldn't say he overdosed. He was poisoned. The man did not do fentanyl, right? He was poisoned with fentanyl. He had 15 nanograms per milliliter of fentanyl in his blood, approximately 5 times the legal limit, and then another 20,000 nanograms per milliliter in his stomach, enough to kill more than 6,000 additional people. And it has been a long time since I lived in Summit County, Utah, but that would be a big portion of the county. Okay. Now, just to kind of bring everybody on the same page here, because it's been a while since we've done a video on the Kouri Richins case. Eric's family suspected his wife, Kouri Richins, like long before this happened. He died in 2022. Back in 2019, Eric had an incident where he fell violently ill after drinking something that she prepared. And he confided in his sister that he believed his wife, Kouri, was the person who did it to him. Like she tried to poison him. And being suspicious of that, he changed his life insurance policy. He removed Kouri as the beneficiary and named his sister instead. And this, by the way, guys, if you go to my website, I've got a pretty darn good case file on Kouri Richins. So on the night of his death, Kouri claimed that they were celebrating a property sale and that she made Eric a Moscow mule. And she then said that she found him unresponsive. Hours later, called 911. However, she did some suspicious things, and this is where I'm grateful for just stupid criminals. Guys, you know Gavin's iron law, right? If you think you've got what it takes to be a criminal mastermind, that is evidence that you do not have what it takes to be a criminal mastermind. You're not smart enough. And this woman, according to the evidence, planned her husband's death. And all the while kind of keeping this facade of a perfect family intact, right? Yeah, but dumb. Just dumb. You know who's not dumb, though? Her attorneys. And her attorneys, earlier this month, filed a couple of motions in Summit County Court and are seeking the suppression of a couple of vital pieces of evidence to the prosecution's case. They had a hearing on this just, I think it was day before yesterday, and we don't have an order from the court yet. I checked and I did not see a new order from the court. But what I want to do tonight is I want to go through the motions, maybe talk a little bit about what they are. Okay. Do you remember that there was oh my goodness, such a stupid criminal. I can't even tell you, but if you go to the website, goodness, there is so much on here. The amount of debt that she had because of her real estate stuff that she was doing, the stupidity of the text messages that she sent to her alleged co-conspirators, just so much. There's so much, guys, so much. So go over to the website and check it out. All right. Join me, will you, over here at Adobe Acrobat, and we shall hop into this, okay? This is a motion by the defense, okay? In Utah v. Kouri Richins, the defendant. Okay, this is just a few pages. Kouri Richins, by and through counsel, hereby moves to suppress the 6-page letter that has become known as the Walk the Dog letter. Here is the Walk the Dog letter. Okay, guys. Here's the thing about criminals. They think they're smart. They think they're smart, and they think that they can write in code and that nobody is going to understand the code. But unless they have like some secret cryptex in their cell, or know a language that is dead to all the world but them and their conspirators, you can just see right through it. I once sat in a trial. I was covering a trial. This wasn't very long ago, a couple years ago, where the man who was eventually convicted of murder, so the murderer in the case, had offered to give a hitman, a would-be hitman, let's say that, his home, if like the murderer's home, if he would off the main suspect or the main witness. And he wrote it in a way where he thought that he was being cryptic about it. He was not. Nor was Kouri Richins when she's talking to her brother here and basically telling him to keep his lips zipped and instructing him on how to testify or talk to the police. Okay. This motion is filed pursuant to Rule 12 of the Utah Rules of Criminal Procedure and provides the following in accordance with said rule. Ms. Richins seeks to suppress the 6-page letter known as the Walk the Dog letter, found in her cell and seized on or about September 14th, 2023. Ms. Richins has standing as the letter was written by her and was located with her property in her cell. Okay, so they have to establish the standing and everything. The issue raised by this motion is whether the letter constitutes attorney-client work product and or attorney-client communication and is therefore privileged. Here we go. Factual background. On or about September 13th, 2023, Ms. Richins was transported to the hospital after suffering a medical incident in her cell. While Ms. Richins was at the hospital, jail staff entered and searched her cell, possibly looking for a letter that Ms. Richins had shown her mother during a video call. Nothing was initially taken from the cell. However, over the course of the following 24 hours, the cell was searched 2 additional times. During the final search on September 14th, 2023, jail staff seized the 6-page letter, now known as the Walk the Dog letter. Ms. Richins maintains that the letter was located in a manila envelope marked Sky Lazaro Attorney Privilege, whereas jail staff has stated that the letter was located folded in a book titled 10 Actual Official LSAT Prep Tests. The LSATs, by the way, guys, are the tests that you take to pass the bar. There are some states, I don't know if Utah is one of those states, where you do not need a law degree or any degree to take the LSATs. If you can pass them, you're a lawyer. Anyway, well, you're not a lawyer, you're an attorney. The letter is not addressed to anyone, and there is no evidence that the letter was shown or mailed to any person. The letter, at least in part, discusses conversations and legal strategies that took place with Ms. Richins' former counsel, Ms. Lazaro. Analysis. Okay, and let's bring Eric's picture back up here, okay, while we talk about this. I think that there is a danger of abuse of trust with law enforcement officers and with corrections officers. I get dry mouth as I'm doing this, so sorry, guys. Okay. There is a potential for an abuse of trust. So when a police officer, for example, writes a criminal complaint against somebody, they swear under oath that the things that they put in their affidavit of probable cause or in their criminal complaint are true. And they're sworn under oath. It would be like being in court and raising your hand and swearing in front of a judge, the whole thing. But history teaches us or informs us that police officers and corrections officers lie frequently. And sometimes they do it because they think that it's justified, that their behavior is justified. They go, I know that this suspect or this defendant or this inmate did what he or she is accused of doing. Therefore, I'm going to make it easier. I'm going to lie under oath so that whatever evidence can be admitted or whatever it is that they're trying to do. So having said that, this portion of the letter where her attorney says Ms. Richins maintained the letter was located in a manila envelope marked Sky Lazaro Attorney Privilege, whereas jail staff has stated that the letter was located folded in a book titled 10 Actual Official LSAT Prep Tests. Okay, the likelihood of there being body-worn cameras or cameras in the cell that they went in to take a look at is pretty low, having not read ahead. Okay, but that is pretty low, and that leaves open the opportunity to lie. So right now it's a he said, she said kind of a situation, except that the officers in question will have made their statement under oath. And I think the court tends to, not specifically this court, but courts in general tend to believe officers, sworn officers. Okay. All right. So analysis. It is well settled that communications between client and their attorney are protected by privilege. This privilege is recognized in both Rule 504 of the Utah Rules of Evidence and by statute. In the matter of Doe v. Merritt, blah, 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 the Utah Supreme Court stated that the attorney-client privilege is intended to encourage candor between attorney and client and promote the best possible representation of the client. It is the oldest of the common law privileges protecting confidential communications. And you and I, we want there to be attorney-client privilege. This is something that is unique to the United States, Great Britain, and the Commonwealth countries, right? This is something that dates all the way back to the Magna Carta. This is very, very important. And if the fidelity of the law is the most important thing, which it really is, in my opinion, then we want our defendants, no matter how much we believe or even know that they are guilty, we want them to have the most competent, best representation they can possibly get so that it's fair, so that when they are ultimately convicted, if they are convicted, it is done fairly and it will not fall on appeal. Okay? End of rant. Okay. All right. Courts have made clear that the Utah Rules of Evidence provide that a client has a privilege to refuse to disclose and to prevent any other person from disclosing confidential communications if 1. The communications were made for the purpose or in the course of obtaining or facilitating the rendition of legal services to the client, and 2. The communications were A, between 1. The client, and 2. The legal professional or the legal professional's representatives. However, the privilege may be waived by a client who discloses or consents to the disclosure of any significant part of the matter or communication. It says, it is perfectly clear that once privileged material is disclosed without claiming the privilege, the privilege of non-disclosure is waived. State v. Johnson. Okay. In Utah, the question of whether the disclosure constituted a waiver turns on whether the disclosure was voluntary or excusably inadvertent. The work product doctrine is a judicially created doctrine now codified in Utah Rule of Civil Procedure 26b-6. The work product doctrine protects documents that are prepared in anticipation of litigation or for trial by or for another party or by or for that other party's representative. Documents that convey the mental impressions, conclusions, opinions, or legal theories of an attorney or party are afforded heightened protection as opinion work product. The party asserting work product privilege has the burden of establishing its existence. Okay, for written materials to fall under work product privilege, 3 criteria must be met. 1, the materials must be documents and tangible things otherwise discoverable. 2, prepared in anticipation of litigation or for trial. 3, by or for another party or by or for that party's representatives. For a party to assert work product protection, the party must show that the documents or materials were prepared in anticipation of litigation by or for a party or that party's representative. Pursuant to the Utah Rule of Criminal Procedure, the defendant's disclosure obligations do not include information or material that is privileged or attorney work product. Attorney work product protection is not subject to the exception in Rule 26b-6 of the Utah Rules of Civil Procedure. Okay, the letter at issue meets the criteria to fall under work product privilege. It is a tangible document that discusses legal strategies in preparation for trial, prepared by or for another party. Further, according to the defendant, the letter was in an envelope that was marked as attorney-client privilege. It's interesting to me that they bring up that the first thing that they bring up is, hey, no, this qualifies as work product because it was prepared by or for another party and it discusses legal strategy in preparation for trial. Then they move on to the second part. The defendant says the letter was in an envelope that was marked as attorney-client privilege, and even if the letter was in a book, it clearly discusses legal strategy and still meets the above criteria. It is neither addressed to anyone nor signed by Ms. Richins, and there's no evidence that she intended to disclose it, thereby waiving privilege. Lastly, the letter has been identified as part of the fictional manuscript that this court has previously ruled is privileged, and therefore is part of the manuscript, as part of the manuscript, is clearly privileged. Ms. Richins anticipates that further briefing will be required following the evidentiary hearing in this matter and requests leave of the court to supplement this motion with a memorandum of facts and law upon the conclusion of the hearing. And again, that hearing was already held. So this, guys, this is one of those things where I think that she probably has a strong argument here. She may be a stupid criminal, but I think that she's being competently represented by Ms. Lewis, Ms. Nestor, Mr. Ramos. I think they're probably doing a great job. Now, what will this mean to the prosecution? What will it mean? Well, I mean, there's a lot of damning evidence in that document that will not be admitted into the trial if it gets to trial and if they win this motion. I think they've got I think they're in a good place. I think that they probably will win this motion. I would be really surprised if they didn't. Now let's go over and see what you guys are talking about over here. Give me a second. Where are we? Let's get it refreshed. Okay. Here we go. Phoenix Rising. Gavin, if we had Oscars of true crime in the category of dumbest criminal, Kouri would definitely be a nominee, if not the winner. We should. What would we call them? What would we call them? Maybe she could get an honorary award, and then we could name the award after her. We would call them the Kouris. What do you think? That's pretty funny. Let me go down. Phoenix Rising again. Gavin, I swear, the first time I heard the walk the dog letter elsewhere, a little voice in my head said, "Come on into Uncle Gavin's class of how to get away with murder." Yeah, I don't think Uncle Gavin has made an appearance lately. I do see that my niece is in the live stream, so for her, Uncle Gavin's around anyway. Let's see if there's anything else that you guys are saying in here. Mooney says yes to the Kouris. We could call them the Kouris. Okay, I should have had it. We will call them the Kouris. We will make a little trophy, and Heather Whatever says she will get the Lifetime Achievement Award. That's pretty funny. Okay, let's go back. Let's go to the next one, okay? Join me, will you, over at Acrobat. Let's move on. Okay, all three of these motions were submitted at the court the same day, which was January 8th. Okay. This one's a big one. I think it probably is a little bigger of a reach, but it brings up an interesting legal doctrine. And I haven't read this whole thing yet. I've just kind of read the first couple paragraphs. Okay, Kouri Richins, by and through counsel, hereby moves to suppress all evidence obtained from the search of Kouri's cell phones and Apple user IDs pursuant to search warrants. Now, you guys know that is basically the case. The case is all of the communication that she had with the Dillhole idiot co-conspirator drug dealers / cleaners that she was trying to get drugs from. That, I mean, there's other evidence for sure, but it all starts with that. Being able to document those communications and then with timestamps and everything, go to different locations and get video and all that stuff. It is a huge part of the case. All right. Motion is blah, 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 blah. Kouri seeks to suppress the contents of the search of her cell phones. She has standing because they're her cell phones and Apple IDs. And the issue raised by this motion is whether the searches were based on a warrant that lacked particularity and was overbroad. So the argument is the search warrant was broad. It was broad. It was overly broad, and therefore it shouldn't be valid. Now, again, we already talked about this, right? We want the legal system and the judicial system to maintain their fidelity, their truthfulness, their fidelity. That's the best word. We want law enforcement to, when they write a search warrant, we want them to be very specific, and we want judges to hold them to account, not grant search warrants that aren't very specific. Now, I can think of another case. I can think of a case in New York State. I'm not going to give you the details on it, but it happened in New York State where a search warrant was written for a property. When they went into the property, they went in expecting to find something, but ended up finding lots of somethings, and they were not in plain view, and they were in different places in the house. So, having discovered that something bigger was happening, they backed out of the house. They wrote a new search warrant affidavit and submitted it to the court. They were more specific about it, and the court granted them the new search warrant. So once they got that, they went back inside and did the search. Now, this actually ended up being a problem for prosecutors because it wasn't until the evidence was first found that they went, oh, we need a better, bigger search warrant here. Therefore, the defense was like, this is fruit of the poison tree. So this is very important. In fact, come to think of it, there is an older case in the New York State case that I was just talking about. The man ended up pleading guilty. But if you go over to my website and scroll on down almost to the bottom, I think, go to the Janie Manning case. This is from 1972. The man that was accused of her murder was found not guilty because his lawyers were able to exclude the mountain of evidence against him because the police did not properly execute a search warrant, nor did they Mirandize him. I mean, it was a mess, right? We want our police officers we want our suspects, our defendants, to have the best chance of fairness in order for the whole system to work, right? So, I mean, there are tons of cases like this. Okay. Relevant background. Kouri was arrested May 8th, 2023. Remember that Eric was killed on March 4th, 2022. In that time, she had time to write a children's book, for crying out loud. Kouri's phone was taken from her during her arrest. 2 hours later, a warrant was issued. The warrant authorized the search of 1. Electronic documents, 2. Email, instant messaging, and text messages, 3. Personal communications, 4. Internet history, 5. Personal and business schedules, 6. Photographs, images, and video, 7. Contacts, lists, and phone numbers, 8. Call history, 9. GPS location history, 10. Social media activity and messages, 11. All other digital activity stored on the device. And I think that's probably the overly broad sentence. On May 8th, 2023, during the execution of a search warrant of Kouri's residence, a phone was found in a drawer, and a warrant was requested and issued for the same 11 items above. On June 27, 2023, a warrant was issued for a white iPhone 13 belonging to Kouri Richins. The same 11 items were requested. Lastly, prior to Kouri's arrest, a warrant for her Apple information was issued. That warrant requested the following: device registration, customer service records, Apple Media Services, Apple Store transactions, Apple.com orders, gift cards, Apple Cash, Apple Pay, Apple Card, iCloud, Find My, and blah, 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 blah. Like, we'll just, so many of all the things. Okay. Detectives had the ability to limit their scope, but chose not to. Instead, they left it broad, not even limited to the date of the alleged crimes. Well, yeah. But okay. The grounds for suppression. The warrants were improperly issued because the supporting affidavits lacked particularity and were overly broad. As a result, the searches violated Kouri's right under the Fourth Amendment of the United States Constitution and Article 1, Section 14 of the Utah Constitution. Okay, let's figure out what the legal doctrine of lack of particularity means. The Fourth Amendment requires that warrants particularly describe the place to be searched and the persons or things to be seized. The affidavit in support of the warrant in this case failed to meet the standard with respect to the search of Kouri's phones and Apple IDs. The warrants authorized a search of the entire contents of the phones and IDs without specifying the particular information sought, limiting the scope of the search to evidence related to the alleged crimes of murder and attempted murder, or establishing a limiting search procedure. This broad authorization allowed law enforcement to conduct a fishing expedition through Kouri's private data, far exceeding the permissible scope of a warrant. So I don't know that I buy that. Let's go back to when the Constitution was written, right? The Bill of Rights and later all of the amendments that were added. Of course, they weren't thinking about digital devices at all. So if I said to a court, hey, I want to, I don't know why I would do this, but I would like to search Mooney's outhouse because I believe I'm going to find something incriminating there. And I'm naming you Mooney because I know you'll be a good sport, right? Well, the digital device in this case, I believe, is like saying the outhouse or the closet or whatever, the garage, the carriage house, whatever. I just think that I think they're going to fail on this one. I really do. I mean, she allegedly conspired to kill her husband over the course of a few years. I think she attempted 3 times, and on the 3rd time she succeeded by giving her husband a dose of fentanyl that was greater than what was needed for, what was it, 6,000 people? Overkill is certainly appropriate here. And I don't think that it was a fishing expedition. I do not think that it didn't meet this particularity. The 14th Amendment the 4th Amendment particularly described the place to be searched and the person or things to be seized. Well, the place to be searched would be the phone, and the things to be seized would be the electronic documents, email, IM, text messages, personal communications, and so forth. I think that was pretty particular, but I'm not a lawyer, so that's just my opinion. Over breadth being overly broad. The warrants were overly broad in that they allowed the seizure of all data on Kouri's phones and Apple IDs, regardless of its relevance of the alleged crime of murder. I think they always do, man. Like, every time they do a digital device search, they download the entire thing. Okay. The affidavit failed to establish probable cause to believe that all data on the phone, including personal communications, photos, and other private information, would contain evidence of criminal activity. The warrant should have been limited to specific types of information or files that were reasonably likely to contain evidence related to the alleged murder and attempted murder. I think they did. Okay, the argument. The search of Kouri's cell phones and Apple IDs was a violation of her constitutional rights. The affidavit supporting the warrant lacked the necessary particularity to justify such a broad intrusion into her private life. The warrant's overbreadth allowed law enforcement to seize a vast amount of data unrelated to the alleged murder, violating Kouri's reasonable expectation of privacy. The warrants in this case failed to adequately protect these interests by providing specific limitations on the scope of the search. Defense requests evidence to be taken on this issue at the previously scheduled evidentiary hearing, blah, 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 blah. That's the 8th of January once again. So, yeah, the thing that I've thought about on this one is just the fruits of the poison tree argument. Everything that they have, I probably shouldn't say everything, but like the vast majority of the case against Kouri Richins comes from her dillholery in regards to her digital devices. Let's see what you guys have to say here. Give me a second to get on over here. Autumn says, I don't feel they were broad. They said everything they wanted to see in the phone. Maybe they wanted a to from date. I think that the police would be able to. Man, I just dropped my. Please hold. Dropped my wedding band. I tend to play around with this. I mean, they had information that as far back as 2019, she, or at least the family suspected that she had attempted to kill him. So, okay. Jesse Essex says, new case law shows that searches of cell phones are too broad in general. They've been limiting the searches in Supreme Court rulings on appeal, even in Utah. Interesting. Okay, good. Gavin, I think this judge is top notch and will follow all laws and due processes. That's what we want, right? That's exactly what we want. Danielle Mann, just tuning into tonight's stream, but I'm relatively familiar with the case. I'm convinced Walk the Dog was meant to be the equivalent to Burn After Reading. Have you seen Burn After Reading, the movie, Coen Brothers movie? Yeah, Kouri Richins is the Brad Pitt character in Burn After Reading. That's what she's equivalent to. Yeah. It's Mooney. Stay out of my outhouse. And yes, there is a moon carved on the door. Of course there is. Of course there is, Mooney. Thanks for being a good sport. Okay, last document that we have here is this motion to suppress Racha. This is the third one. It was filed the same day. Wendy Lewis, Catherine Nestor, Alexander Ramos, her attorneys. Okay, Kouri Richins, bind through counsel, hereby moves to suppress statements made by Kouri Richins from evidence seized from her person and her home. Okay, so this should be interesting. Statement she made. Okay. Blah, 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 blah. She seeks to suppress physical evidence, specifically a telephone and all evidence obtained from the phone, which was seized from her person on April 13th, 2022. Ms. Richins seeks to suppress all oral statements made by her while she was detained on April 13th, 2022 during the search of her home. Because of course she does. I don't think she's going to get this. That's... How many times... Okay, this genius right here. She was like Chatty Cathy. We've listened to the recordings. Or have we listened to the recordings, or we've read the transcripts? We've read the transcripts, right? The reports. She was Chatty Cathy. She goes on to throw a party the day after her husband dies because she's closing on some real estate. She goes on to write a book, Daddy Daddy, can you see me? Or something like that to make her kids feel better about their dad who is dead, who she murdered. She was an absolute idiot. Guys, don't be like Kouri. Listen, none of us want to win a Kouri, right? The only Kouri that we want to pass out tonight is the Lifetime Achievement Award. Okay. Dang it. We've got to come up with a Kouri award. Anyway, don't be like Kouri, kids. Uncle Gavin says, don't be like Kouri. Okay. When the police want to talk to you, you don't know. The answer is no. You don't want to do that. Okay. Ms. Richins seeks to suppress oral statements she made during an interview with Sergeant O'Driscoll at her home, April 14th, 2023. Ms. Richins seeks to suppress a handwritten statement seized from her home on May 8th, 2023, on the grounds that it was seized without the proper authority of a warrant and is protected by physician-patient privilege. Ms. Richins has standing, blah, blah, blah. The first issue raised by this motion is whether the physical evidence seized from Ms. Richins' person, specifically a mobile phone, was seized and or accessed without the lawful authority of a warrant, and whether all evidence seized from that phone is fruit of the poisonous tree. The second issue raised by this motion is whether the statements in paragraph 2 above were custodial statements made by Ms. Richins without the benefit of being advised of her Miranda rights. Okay. You know, one of the things that police will do, see, they are not required to Mirandize people in certain situations. Like a person who's just a person of interest, they're not required to Mirandize them. If they're a suspect, if they're suspicious of that person, and I know that I'm no lawyer, and there's definitely arguments to be made either like one way or the other, but the point is that there are circumstances where police do not have to Mirandize somebody, and it's been upheld by the Supreme Court. Okay. But what they're saying here is that she should have been Mirandized. The third issue raised by this motion is whether the statement in paragraph 3 above was obtained in violation of Ms. Richins' constitutional rights, considering her right to have an attorney present was previously invoked. She invoked wanting an attorney. The fourth issue raised by this motion is whether the statement described in paragraph 3 above was seized without the proper authority of a warrant, and if so, whether it is protected by the mental health therapist patient privilege. Ms. Richins respectfully requests an evidentiary hearing and subsequent leave to file a memorandum of authorities in support of the motion. Here's the background. April 13th, 2022, search warrants were executed on Kouri Richins' home, and items were seized from her house. During the search, Ms. Richins was pulled over in her personal vehicle a short distance away from her home. Law enforcement officers seized her personal phone from her vehicle without the authority of a warrant. For over 5 hours, Ms. Richins was not free to leave the scene. At the time of the search, law enforcement was aware that Ms. Richins was represented by counsel and even had set up a time for counsel to appear with Ms. Richins the next day at 8:30 a.m. Okay, during the time that she was detained, Ms. Richins was questioned by law enforcement without the benefit of a Miranda warning. Law enforcement used the information they received from Ms. Richins' custodial statements on April 13th to obtain physical evidence to use against her. Okay, if this is true, then I'm angry because a person who I believe definitely killed somebody could get away with it because if this is true, because of law enforcement's malpractice or malfeasance. And this should make everybody mad, if it's true, okay? On April 13th and 14th, Ms. Richins' attorney sent an email to the Summit County Sheriff and to the County Attorney's Office advising that their firm represented Ms. Richins and objecting to their attempts to question Ms. Richins outside of counsel's presence. Copies of these letters were sent directly to the main case investigator on April 14th, 2022. On April 18th, 2023, Detective O'Driscoll appeared at Ms. Richins' home with another police officer and hidden recording devices and questioned her for over an hour, despite the previous invocation by counsel of Ms. Richins' Fifth and Sixth Amendment rights. I think that, but previous invocation of counsel by Ms. Richins, Fifth and Sixth Amendment, or whatever. Okay. And no time during this interview was Ms. Richins advised of her Miranda rights, and her attorney was given no advance notice this interview was going to take place. Ms. Richins was arrested on May 8th. On the same day, law enforcement executed a second search warrant on the Richins' home. This warrant did not authorize the search or seizure of documents. While the officers were searching the home, they came across a closed notebook. The officers opened the notebook, read its contents, and then sought an amended warrant with authority to seize the notebook. Now, this is the same kind of situation that I was telling you about in the New York case. The officers' acts of opening and reading the notebook without authority of a warrant to do so violated Ms. Richins' Fourth Amendment right to be free from unreasonable searches and seizures, and tainted the secondary warrant since it was based on this unconstitutional seizure. This document was prepared at the request of and for review by Ms. Richins' therapists and is privileged. I'm telling you, if they did this as it is described in this motion, then it would be proper for the court to throw out the evidence. All of it. Like, it would be proper to do so. Grounds for suppression. And you know what? The attorney, not the attorney, goodness, Gavin, the judge in this case should take special care, should take special care, because this will be something that will be the basis of an appeal later on if that judge does not rule properly. Okay, the seizure of Ms. Richins' phone from her person on April 13th, 2022. The Fourth Amendment to the United States Constitution provides citizens with a right to privacy and prohibits unreasonable searches and seizures of their persons or property. The seizure of Ms. Richins' phone without the proper authority of a warrant violated her Fourth and Fifth Amendment rights. Because Ms. Richins was not arrested on that day, the incident to arrest exception to the warrant requirement does not apply, nor do any other exceptions. Oral statements made by Ms. Richins while she was detained on April 13, 2022. The Miranda safeguards apply when an individual is taken into custody or otherwise deprived of her freedom by the authorities in any significant way. 5 hours that she's not allowed to leave, that is significant. At the time of Ms. Richins' statements on April 13, 2022, she was not free to leave and she was not Mirandized. Therefore, any statements obtained from her during this time violated her Fifth and Sixth Amendment rights and must be suppressed. Any evidence obtained as a result of her statements must similarly be suppressed as fruit of the poisonous tree. The Fifth Amendment creates a privilege that protects a defendant against being incriminated by his own compelled testimonial communications. An individual has a Fifth Amendment right to refuse to provide a cell phone swipe code to investigating officers. Ooh. Did they make her do that? Okay, the interview with Detective O'Driscoll. O'Driscoll conducted the interview of Kouri Richins while on notice that she was represented by counsel and that her prior counsel had invoked her Fifth and Sixth Amendment rights. Even knowing this, he proceeded with the interview with the intent to get Ms. Richins to incriminate herself, knowing she was going to be arrested shortly thereafter. At no time did he offer Ms. Richins a Miranda warning. Such an interview was a clear violation of Ms. Richins' Fifth and Sixth Amendment rights. The handwritten statement in the orange notebook seized on May 8, 2023. The warrant authorizing the search of Ms. Richins' home on May 8th did not authorize law enforcement to seize and review documentary evidence. Nevertheless, officers opened up a closed notebook and read the contents. Realizing they did not have authority to do so, they obtained a second warrant, attempting to authorize the illegal seizure they had already conducted. The seizure of the notebook violated Ms. Richins' Fourth Amendment right to be free from unlawful searches and seizures of her private writings within the privacy of her own home. Furthermore, Rule 506 of the Utah Rules of Evidence provides that documents prepared under the direction of a mental health therapist for the purpose of mental health treatment are privileged documents and cannot be introduced at trial. The defense requests evidence be taken on these issues at the previously scheduled evidentiary hearing. Additionally, defense anticipates that further briefing will be required following the evidentiary hearing in this matter and requests leave of the court to supplement this motion with a memorandum of facts and law upon the conclusion of the hearing. That hearing was held. Guys, that bothers me. That really bothers me that, what am I putting her picture up? Let's put up his picture. That if what is true, if what is alleged in this motion is true, how do I say that? If the facts alleged in this motion are true, then the prosecution has a problem. And they should have a problem. The police should not be behaving that way if they did indeed behave the way that it was alleged in this document. Let's pause one more time for some of your comments here. Let's go on down. Medi says, Gavin, did she ever win the case against her husband's estate that she filed after her arrest? I don't know, and I don't think so. But I don't know. I'll have to do it. Gavin, I want to hear the state's response to all this. Do we have it? So they had an evidentiary hearing, but in the docket, any written response isn't there yet. So I imagine that it'll be coming in the next couple of weeks. I'll keep my eye open for it because we want to come back to it. They still have the drug dealer's admission if they throw out other evidence, though. Yes, except Medi, they got to the drug dealer by learning about the drug dealer from the phone. That is the fruits of the poison tree doctrine. That not just what you got from the ill-gotten evidence gets thrown out. It's everything that you got because of that gets thrown out. So, I mean, there's a lot there. And Heather, whatever, saying, whoa, is right. And then Jesse says, they claim the Sixth Amendment does not attach because she was not charged yet. Yeah, that is a trick. That is a trick that law enforcement uses to try to get around Miranda. And it's been upheld by the court by the U.S. Supreme Court in certain cases. So, I mean, yeah. Let's see. Jesse says the state conceded to the improper seizure of the orange notebook at the hearing. Okay. Do you think the evidence is exaggerating? They could be. It's possible that they did. Typically, though, I mean, they have to be able to make the argument. They shouldn't exaggerate for the court. But I think, I think probably what they are alleging is true. Yeah. Yep. So anything they used from the phone. Yeah. And that is scary. I mean, it's absolutely scary. And listen, I mean, I know this is a case from 1972, but this is exactly what happened in this case. This guy, what was the name of his, Frank Sidlowski. Yeah. Like, he was found not guilty. And I've gone through everything, guys. He's dead now, and so are everybody attached to everything. So I can just say, like, yeah, I think he was guilty and he got off because police officers sucked at doing their job. Investigators sucked at doing their job. And if that happens in this case, but here's the thing, like, if they did do the things as alleged in the motion, they have to win that motion because the fidelity of the law is so important. Okay, couple things that we learned from this here live stream. Okay, number one, we are naming the Stupid Criminal Awards the Kouris, and we're spelling it Kouri. They are the Kouris. Okay, that is number one. What is the second thing that we learned? Oh, the second thing we learned in this here live stream is that we are all of us, but especially me, are to stay out of Mooney's outhouse. That's what we learned. Okay. Hey guys, tomorrow we are going to be moving on to the case of Nazia Harris. Oh my goodness. So Autumn brought this one to me. Jamie brought this one to me. Pat brought this one to me. I've seen it. Several of you have brought it to me in my inbox. This is the Madeline Soto case on steroids. It's just basically take all of the Florida weirdness and replace it with Michigan weirdness, Detroit weirdness. This is a sad, sad case of a young girl who lived a sadly and terribly abused life. So if you have cared about the Madeline Soto case, you should care about the Nazia Harris case, and we're going to start our coverage on that case tomorrow at 7:30 Eastern. While I've got you here, please head on over to the Fish Tank and join us. We're over 34 members strong over there. Talk about all things true crime. So if you're on Facebook and it's your deal, please join us there. Check out CrimeCod. All you have to do is click CrimeCod at the top of my website. That will take you over to the CrimeCod website. If any of you, by the way, are aspiring reporters or want to be amateur journalists and want a little training and want to write for CrimeCod, you can reach out to me. I'd love to talk to you about it. While you're on CrimeCod, check out the newsletter, subscribe. I know I keep promising this, but I'm getting close to being able to send out a daily, meaningful true crime newsletter that won't be spammy and won't be annoying, that'll be easy to unsubscribe to and all the things. Okay, so check out CrimeCod. If you want to reach out to me, click on this little button right here. That will take you to this page, which is a little form that you can use to reach out to me. Also, in the link below, in the description below, you should find a link to my file drop. If there are any documents that you want me to see, just click on that link. You can upload files to me now. Okay. All right, guys, with that, thank you so much for being here. Thank you very much to Aura for sponsoring this video. I will see you tomorrow, 7:30 Eastern, right here on the channel. Until then, I bid you adieu. See you then. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.